Welcome to the State of Hawaii Department of Human Services Mandated Reporter Virtual Training for 2021 through 2022. Child Abuse and Neglect, Human Trafficking by Evelyn Lum. Disclaimer: Intellectual Property Rights. This presentation is intended only for educational purposes and do not replace independent professional judgment. Statements of facts and opinions expressed are based upon HRS 587A and the Chapter 350. This pre-recorded presentation is being provided exclusively to Children's Justice Center of Hawaii. No duplications or alterations of this presentation is allowed without prior written approval of the Department of Human Services, Social Services Division, Oahu Child Welfare Services Section 3, Intake Unit. It should be used as a tool for mandated reporter training of child abuse and neglect and human trafficking. Child Welfare Services Mission. The mission of Child Welfare Services Branch is to ensure the safety and permanency of children in their home or when necessary in out-of-home placements. The Child Welfare Services Branch has offices on the islands of Oahu, Hawaii Island, Kauai, Maui, Molokai, and Lanai. The Department of Human Services oversees 5 divisions. Child Welfare Services is a branch of Social Services Division. CWS provides social services to families and their children who have been harmed or at risk for harm. Office of Youth Services, the Division of Vocational Rehabilitation, Benefits, Employment, and Support Services Division, and our MedQuest Office Division. Child Welfare Services Programs. We have contracted services for family strengthening services, support, voluntary case management, child protection, which is a CWS investigation, foster care, adoption and legal guardianship, independent living. We also license resource caregivers, both kin and general license, as well as child placing organizations and preschools. The difference between child welfare services and law enforcement. Child welfare services is not a criminal matter. It is actually a civil matter. There is no criminal consequence, only removal of children. This requires only a preponderance of 51%, reasonable cause to believe, more probable than not, versus a criminal beyond a reasonable doubt. The highest level of proof, no other logical explanation. We determine whether the harm has occurred. In a civil matter, we conduct assessments regarding the safety of the home. There's a protection action. There's a safety plan implementation. We provide therapy and healing of the harm. In regards to law enforcement, they determine whether a crime has occurred. Information and evidence gathering. Is there a probable cause to bring criminal charges? Because the majority of the reports filed with CWS are based on threatened harm, without occurrence of any incident of actual harm, many reports do not constitute a criminal offense and therefore no prosecution. The statutes for protecting children. The Hawaii Revised Statute, HRS Chapter 587A, is a new statutory identification coinciding with the statutory changes effective August 2016. And 350 provides the statutory foundation for service intervention. HRS Chapter 587A, Child Protection Act. The 587A Child Protection Act, the definition of harm, the key service providers, and service action. The entire thrust of the 587 is to make paramount the safety and health of children who have been harmed or are in life circumstances that threaten harm. The Act serves to safeguard, treat, and provide permanent planning for children who have been harmed or threatened with harm. The statutory definition of child abuse and neglect. It is the act or omission by a family member that cause harm or substantial risk to a child's physical and psychological welfare. The statutory definition of harm, HRS 350 and 587A. Harm means damage or injury to a child's physical or psychological health or welfare, where number 1, the child exhibits evidence of injury including, but not limited to, A. Substantial or multiple skin bruising or any other internal bleeding. B. Any injury to the skin causing substantial bleeding. C. Malnutrition. D. Failure to thrive. E. Burn or burns. And F. Poisoning. G. Fracture of any bone. H. A subdural hematoma, a bleeding on the brain. I. Soft tissue swelling. J. Extreme pain. K. Extreme mental distress. And L. Gross degradation. M. Death. And the injury is not justifiably explained, or the history given concerning conditions of death is a variance with the degree or type of such condition or death, or circumstances indicate that such condition may not be the product of an accidental occurrence. Number 2, when the child has been the victim of sexual contact or conduct, but not limited to sexual assault as defined in the Penal Code, molestation, sexual fondling, incest, or prostitution, obscene or pornographic photographing, filming, or depiction, or other similar forms of sexual exploitation, including but not limited to acts that constitute an offense pursuant to Section 712-12-2, or number 3, when there exists injury to the psychological capacity of a child, as evidenced by the observable and substantial impairment in the child's ability to function. Number 4, when the child is not provided in a timely manner with adequate food, clothing, shelter, psychological care, physical care, and medical care or supervision. When the child is provided with dangerous, harmful, or detrimental drugs as defined by Section 712-1240, provided that this paragraph shall not apply when such drugs are provided to the child pursuant to the direction or prescription of a practitioner as defined in the 712-1240. A dangerous drug means any substance or imminent precursor controlled substance as defined by Department of Health, defined or specified as a Schedule 1 or Schedule 2 substance by Chapter 329. Exception: marijuana or a marijuana concentrate. A detrimental drug means any substance or imminent precursor defined or specified as a Schedule 5 substance by Chapter 329, or any marijuana. A harmful drug means any substance or imminent precursor defined or specified as a Schedule 3 or Schedule 4 substance by Chapter 329, or any marijuana concentrate except marijuana. Number 6, when the child has been the victim of labor trafficking under Chapter 707. Identification of harm, actual versus safety versus risk. In the Mandated Reporter checklist, you will see actual harm, safety, risk, circumstances of alleged harm, parental impairment, and prognosis for a safe home. Child abuse and neglect. We define it under imminent harm, threatened harm, psychological abuse and psychological neglect, sexual harm, contact versus conduct, age of consent concerns, medical neglect, physical abuse. Educational neglect is not statutorily covered under the 587A. Under the 587A, the definition of a child. The definition of a child is based on age, a person who is born alive and less than 18 years of age. There are presently no fetal protection laws to allow intervention in utero. The definition of a family. The definition of a family according to HRS 587A-4. When used in the chapter, family means each legal parent of a child, the birth mother, unless legally adopted, the concerned birth father, as provided in Section 587-2A5, unless the child has been legally adopted, a concerned natural father who is not the legal, adjudicated, or presumed father, but who has demonstrated a reasonable degree of interest, concern, or responsibility as to the welfare of the child. Each parent's spouse or former spouse, each sibling, or a person related by blood or marriage, each person residing in the dwelling unit, any other person or legal entity with legal, physical custody or guardianship of the child, responsibility of the child's care. For the purpose of this chapter, the term family does not apply to authorized agency that assumes the foregoing legal status or relationship with the child. In brief, family is viewed as the person related by blood, marriage, legal, household member, or access. The definition of a maltreater. A maltreater is a parent or legal caretaker. Maltreater or perpetrator means the person the reporter of child abuse and or neglect or the department has identified as a person who by acts or admission has harmed or threatened child or children with harm. CWS Services intervention is focused on the parent and caregiver as a maltreater of harm. The parent caregiver is the only party that CWS can hold responsible for a child's safety and require compliance to services. Maltreater is other than the parent or legal guardian or legal caretaker. When the child is being harmed by a family member that is other than the parent, CWS is assessing a parent's ability or failure to protect as a basis for intervention. Human trafficking introduced a non-familial perpetrator to CWS in terms of tracking, referral of child victim population, harmed by a pimp, gang, employer, controlled and intimate partner for sex or labor trafficking. In May of 2017, under federal compliance, Hawaii Child Welfare Services formally commenced with the tracking and referral of population to track informed providers. If you refer to the mandated reporter checklist, the location of the family is required. Although not defined in the statute, the whereabouts of child family must be provided. CWS cannot proceed without a means to locate the victim or family. If no street, home address, at minimum directions to the location, description of location, or identification of work, employment site, school enrollment for children, or area frequent as a means for contact. The first picture is identified as a park. We need a description if they are homeless in their car, if they have a blue tarp, description, physical description of the parent or child. The middle picture is a beachfront. So if they are located near the ocean versus located near a bathroom, physical description of the family, any other information to identify the family would be greatly appreciated. The last picture is a picture of a shelter. And with this address, we are able to go to the shelter and make an assessment. Protective police custody action by a police officer. One of the most significant interventions via HRS 587A that may involve the reporting professional and the public community is the protective police custody. However, the authority to intervene affect protective custody rests only with the police officer as defined by HRS 587A. A protective police custody allows the immediate safety removal of a child due to imminent harm. I've included the badges for every county officer statewide: Hawaii County, Honolulu Police Department, Maui County, and Kauai. The definition of a police officer means a person employed by any county in the state to enforce the law and ordinance for preserving the peace and maintaining safety and order in the community, or an employee authorized by the Director of Public Safety under Section 329-51 or 353C-4 to exercise the powers of this chapter. Powers of enforcement personnel: make arrests, carry firearms, execute warrants, subpoenas, seize property, and other law enforcement duties as designated by the Director. Appointment of employees with police powers and other employees, responsibility, and duties of state law enforcement assigns all the powers of police officers. So that would include sheriffs. At this present time, the Director of Public Safety has determined only sheriffs and narcotics law enforcement officers as meeting the statutory definition of police, authorized to exercise the powers of HRS 587A, involving protective custody. The powers currently do not extend to PSD, ACOs, youth correctional officers, military law enforcement, and federal officers do not share this authority. 587A-8, protective custody by a police officer without court order. A police officer shall assume protective custody of the child without a court order and without consent of the child's family. If in the discretion of the police officer, the officer determines that, number 1, the child is subject to imminent harm while in the custody of the child's family. Imminent harm means that without intervention within the next 90 days, there is a reasonable cause to believe that harm to the child will occur or reoccur. Number 2, the child has no parent, as defined in this chapter, who is willing and able to provide a safe family home for the child. Number 3, the child has no caregiver, as defined in this chapter, who is willing and able to provide a safe and appropriate placement for the child. Number 4, the child's parent has subjected the child to harm and threatened harm, and the parent is likely to flee with the child. So in summary, protective custody means they can only be performed by a police officer meeting the statutory definition, does not require a court order, parental consent, or notification to the parent. Police shall immediately transfer physical custody of the child to the Department of Human Services, unless admitted to a hospital or similar institution with protective custody forms. The Department of Human Services will automatically assume temporary foster custody. The Department of Human Services will make every reasonable effort to notify parent, legal caretaker, unless doing so would put another person at risk of harm or interfere with law enforcement. The Department of Human Services will place the child in a licensed foster home, kin-specific, whenever possible, facility, or admission to a hospital or similar institution, while the department conducts an appropriate investigation with placement preference being given to an approved relative. A pre-placement medical exam is required for all children prior to placement. 72-hour time limit, excluding weekends or holidays. Within the 3 days, the Department of Human Services may relinquish temporary foster custody and return the child to the parent, or secure a voluntary placement agreement, or file a petition with the court to maintain custody of the child. Now we're going to discuss filing a report. Filing a report for child abuse and neglect or human trafficking, eligibility criteria for children that are abused or neglected, and the services intervention. How do I file a report? What information will I need to provide for my oral and written report? What should I be including in your written report, and expectations for the mandated reporters? The definition of mandated reporters. Number 1, any licensed or registered professional of the healing arts or any health-related occupation who examines, attends, treats, provides other professional specialized services, including but not limited to physicians, including physicians in training, psychologists, dentists, nurses, osteopathic physicians, surgeons, optometrists, chiropractors, podiatrists, pharmacists, and other health-related professions. Employees or officers of any public or private school. Number 3, employee or officers of any public or private agency or institution providing social, medical, hospitals, mental health services, including financial assistance. Number 4, employees or officers of any law enforcement agency, including but not limited to courts, police departments, Department of Public Safety, correctional institutions, and parole and probation officers. Number 5, individuals, providers of childcare, employees or officers of any licensed or registered childcare facility, foster home or similar institution. Number 6, a medical examiner or coroner. Number 7, employees of any public or private agency providing recreational or sports activities. Also included under the Hawaii State Legislature amended HRS Sections 350-1 to include additional mandated reporters. House Bill 1942 Act 035 on September 15, 2020, House Bill 1942 related to Child Abuse Reporting Act 035 was signed into law. The purpose of this act is to update Hawaii Child Welfare Abuse and Neglect Mandated Reporting Law by adding members of the clergy, commercial computer technicians, commercial film, photographic print or image processors, administrators, employees of any public or private organization whose duties require direct contact with or supervision of children. This is under the California Child Abuse and Neglect Reporting Act. The mandated reporter compliance. Any person may report, however, mandated reporters must immediately report the matter orally to the department or police and follow up with a fax of the mandated reporter checklist. Penalty or failure to report, knowingly fails to provide additional information or prevent another person from reporting such an incident shall be guilty of a petty misdemeanor. This is investigated by the county police. In terms of liability, protect yourself, report, or seek consultation. Handouts for filing a report of child abuse and neglect. Provides instructions, information required, and expectations for the reporters. Confidentiality of reporter identity is protected by law. However, to fulfill your mandated reporter requirements, you must provide your identity. That is part of the compliance. Immunity from liability. Filing a report in good faith. Mandated reporters must disclose report harm despite information revealed in the context of a privileged communication. What can the mandated reporter expect? Consultation, confidentiality, response to the investigation or follow up with the active case, urgency determination, disposition, cross-report to the county police, potential testimony in family court or preparation, and hopefully value the consultation with the department. Child Welfare Services response action to the reports. The eligibility criteria for Child Welfare Services pertains to the statute. Does the presenting report meet the statutory definition of harm, actual harm? Does the victim meet the statutory definition of a child? Is the alleged maltreater the parent or caregiver of the child? Is there sufficient information to locate the family? Is the report of harm imminent and substantial? Immediately safety issues is identified. Is the maltreater an employee? What are the steps to report to CWS and Child Care Licensing or the director, which is the supervisor? CWS intake response to complainant referral. As the complainant, you are expected and are entitled to the following information. CWS disposition regarding your referral. What is CWS going to do with my report? CWS disposition regarding the outcome of the report, assigned for investigation, What was the findings, determination regarding the harm of the report? Is the department confirming or unconfirming the harm? Follow-up. With our community partners, FSS and VCM, regarding services provided, FSS and VCM contracts do not make a dispositional finding regarding whether harm has occurred. CWS intake response to complainant referrals continued. We're going to talk about CWS organizational structure. We're going to talk about CWS interface with mandated reporters, CWS need of mandated reporters, and specifics to education and social settings. CWS organizational structure. There are 4 primary service decision points in the continuum of CWS services. Intake determines eligibility based on risk or safety for CWS services and urgency of response. Assessment, formal investigation, conducts investigation findings on a report of harm, in or out of home safety plan, voluntary or court-ordered services. Case management, implementation of safety plan and monitors for service compliance. Permanency, permanent removal and substitute care for child or children via guardianship, adoption, permanent custody. Intake unit role and function. We are 24 hours, 7 days a week live response to the Hawaii statewide Central Child Abuse and Neglect Reporting Line. As of May 2017, equal response to the Human Trafficking Reporting Line, the federal tracking on extrafamilial perpetrators. We determine eligibility for child welfare and human trafficking intervention via differential response system, also included institutional harm. We determine urgency of response by the department, conduct 9 system data searches to identify all potential victims, family, household composition, and prior active history of CWS services involvement. We initiate intakes, case registration, and documentation of demographic information and case narrative in the department's CPSS data system. We provide consultation, education, and support to the complainants, mandated reporters during the intake process in compliance with mandated reporter requirements. Differential response system. In December of 2005, the department implemented a differential response system involving the triage of reports to ensure that families receive every opportunity and support and the most appropriate, effective, and least intrusive response without CWS jurisdiction that can be provided by CWS or our community partnership to a report of child abuse and neglect. The continuum of CWS services may include no action by the department, no actual harm, no safety, no risk. An active service provider may already be involved, addressing, minimizing the risk factor. No CWS services needed identified due to an unborn child, out of state, or no access by the identified perpetrator. Family strengthening services. Private contract agency, low risk. No safety issues identified as low to moderate risk referrals, prevention, education service, linkage, outreach services, supportive in nature, usually between 3 to 6 months of monitoring. Differential response system continue. The voluntary case management, private contract agency, moderate risk, dynamics of harm are present, but not imminent or substantial. Family is given the opportunity to engage on a voluntary basis with services, remedy the presenting concerns, and prevent the need for a formal CWS CPS investigation. Formal Child Welfare Services investigation identifies actual harm or safety factors. Reports may meet the statutory definition of harm, substantial, and immediate safety issues are identified. Within 60 days, a report finding of confirmed or not confirmed. The family may be eligible for any of one of these services dispositions, which may change at any given time during the service period, depending on increased or decreased presenting risk or safety needs during the assessment. Differential response system. Differential response system determines urgency of response. Is it substantial or imminent harm is present? Child safety is compromised at the time of the report? Need for protective custody action? Involuntary removal or a voluntary removal? Need for emergency crisis response team to determine placement prevention, safety, kinship care? County police and sheriff as first response. CPS does not have a 911 response capacity. In the field tandem response by appropriate law enforcement, CPS crisis response, and/or assessment social worker. Safety issues for CWS workers. Information concerning the family in terms of the safety of a CWS social worker response is always appreciated and helpful. Information includes drugs, weapons, violence, criminal history, or disease. Assessment formal investigation. Urgency. When the criteria for imminent harm is met, a crisis response team or active worker will respond within 2 hours of receiving the report to assess immediate safety and determine placement needs is imminent. Safety factors cannot be controlled. Removal action required via police or court order. Report that meets one or more of the 15 safety factors and may or may not include actual harm, the statutory definition, are met with a face-to-face response with victim and perpetrator within 2 working days of receiving the report. The assessment worker has 60 days to render a disposition, findings regarding the allegations of harm. The disposition include confirmed investigation conducted by the department revealed reasonable cause to believe that harm or threatened harm occurred. Not confirmed, investigation conducted by the department revealed that there was insufficient information. Establish a voluntary safety plan for service engagement or court-ordered services where families refuse to remedy the safety factors on a voluntary basis. Trafficking distinction, familial versus commercial sex trafficking. In May 2016, Public Law 114-22, the Justice for Victims of Trafficking Act of 2016 further required that a child is considered to be a victim of child abuse and neglect, and of sexual abuse if the child is identified by the state or local agency employee as being a victim of sex trafficking or a victim of severe forms of trafficking in a person, regardless of whether the parent or guardian was involved in the abuse or not, or the neglect. In the discussion of familial versus commercial sex trafficking, CWS will conduct an investigation if the family is identified as exchanging the child for a sex act, for drugs, or for money. In a commercial, it's a non-familial perpetrator, a pimp, a non-relative, that is forcing the child to commit these sexual acts for exchange for drugs or money. This has concluded my presentation on child abuse and neglect under the Chapter 587A and 350. How can I get more information? You can contact the Department of Human Services Child Welfare Services Intake Unit to discuss whether or not a case should be referred. Consultation is always available and welcome. The laws, called the Hawaii Revised Statute, can be found online and in the reference section of major libraries. Sections that apply to child welfare services are found in chapters 587 and 350. You may also visit the Department of Human Services website at http://humanservices.hawaii.gov. Additional information available via the website include but not limited to a guide for parents, mandated reported checklist for child abuse and neglect and human trafficking fillable forms. In closing, You are always welcome to call and consult with Intake social worker via the 24/7 Child Abuse and Neglect Reporting Line at 808-832-5300. The safety assessment of a child is one of the most important roles you will play in your capacity as a mandated reporter. Your responsibility is significant. A child's welfare and the implication for future of a family rests in your response, skills, and decision making. We look forward to your positive working relationship with you. Mahalo nui.